Welcome to Introduction to Environmental Law, IDST 3103, Module 3, Dispute Settlement. We're going to consider the role of the courts, tribunals, and alternate dispute resolution mechanisms in dealing with environmental conflicts. As we learned in the previous module, our legal system is based on the English legal system, and the courts operate in the realm of common law when they deal with private or civil cases. They regulate conduct between or among individuals, including corporations, where no statute or contract applies. In deciding a case, a judge will refer to decisions made in previous cases, and as we learned, this is called stare decisis. Problems involved with pursuing common law actions are cost. Litigation is not cheap. Lawyers are expensive, which leads to the second problem, which is time. It can take an extended amount of time to resolve issues through the courts, sometimes mounting up to years. And at the end of the day, there is the uncertainty of the outcome. All but one jurisdiction in Canada use the common law system. The exception is Quebec, which uses the French Civil Code, or le droit civil. The basic principles and rules of law are derived from the Civil Code that courts interpret and apply on a case-by-case basis rather than prior decisions. The only two jurisdictions in North America that still use this at the local level are Quebec and Louisiana. The term civil law can refer both to the law as practiced in Quebec and in common law jurisdictions to law that deals with disputes between or among private parties. This may also be called private law. Public law, on the other hand, deals with relationships between individuals, including corporations, and society as a whole. Criminal law is one aspect of public law. In these actions, society's interests are represented by the Crown. Civil law, or private law, gives a plaintiff, an injured party, an opportunity to ask the court to make a ruling relating to an experience they've had. The most common form of civil law or private law, accessed by individuals who have experienced some form of environmental harm or damage, is tort law. In a tortious situation, an individual will have a legally recognized right that has been violated, or that they allege has been violated in some manner by another party who is known as the defendant, and the court must decide who is responsible and whether the burden of the loss or harm experienced by the plaintiff, the person who brings the case, should be shifted to another person, the defendant. If it is found that this is appropriate, the court will decide who should pay and how much. Common law actions are conducted according to specific rules that are established in each jurisdiction. In Nova Scotia, it's the Nova Scotia Civil Procedure Rules. If the action is brought in the federal court, there are a separate set of rules, the federal civil procedure rules, that apply. The principal functions of tort law are compensation, deterrence or market deterrence if we're dealing with a commercial defendant, education, and psychological benefit. What do we mean by those? Compensation is the specific remedy that the court will determine is appropriate to correct the problem or issue experienced by the plaintiff. It is hoped that the defendant will be instructed in such a way that they will not act in a similar manner again. That is deterrence. Or if we're talking about commercial defendants, that other businesses, operations, will learn from the mistake of their peer, their colleague, and not operate in such a fashion. That the public at large, through the reporting of the proceeding, will be informed about the event and the consequences, and that the plaintiff and defendant will each go away feeling that the court has valued the information they have brought to them, that they have considered in an impartial and rational manner the arguments, and that whether they win or lose, they will have paid the price or gained the benefit of having gone through the process. Tort law protects both individuals and or their property in our system. How do you prove a case? The first matter which you have to demonstrate to the court's satisfaction is whether or not you have a legal right that the court recognizes as being a basis for bringing the action. Secondly, who has to prove what? In civil law cases and in criminal law cases, whoever launches the action, the plaintiff or the Crown, bears the burden of proof. The standard of proof is the degree to which you must persuade the court of the validity of your case. In private or civil actions, the standard is more likely than not, or on the balance of probabilities. In criminal cases, the standard is beyond a reasonable doubt, reasonable being plausible or possible. And finally, critically in all this is the role of evidence. What the court is allowed to consider in weighing the merits of a case is strictly controlled to ensure that the case is adjudicated appropriately. Evidence comes in two types. Direct evidence is factual, either physical evidence gathered by investigators or the testimony of witnesses informing the court of their own experience of the case. Opinion evidence may be presented by qualified experts. Much of the evidence in environmental cases is based upon expert witnesses, the testimony of individuals whom the court accepts as having special training and knowledge in the field. Often a case will depend on which experts the court believes, the plaintiffs or the defendants. Expert witnesses are often found in universities, professional associations, and industry. With environmental law cases, there are typically 5 elements that have to be considered by the court. The first is the duty of care. Should the defendant have taken into account the welfare of the plaintiff when considering the outcome of their activities or omissions, and to what extent? Accidents do happen. However, most actions will have some consequences, and what the court is seeking to determine is whether a defendant, in acting in a specific way, ought reasonably to have recognized that their actions would have consequences. When speaking to the standard of care, the courts have looked at normal practice for activities and weighed them against potential injuries which may result. The greater the risk, the higher the standard of care the court will require. The plaintiff must prove that it was the defendant's activity that caused the damage or injury they experienced. This is sometimes referred to as the but for. But for the action of the defendant, I would not have, etc. Is the cause and effect relationship close enough to hold the defendant liable for the loss? Proximity. Was it reasonably foreseeable that the defendant's act would result in damage to the plaintiff? I liken this to the domino effect. If you can draw a direct line between pushing the first domino and the last one toppling over, then you have proximity. If, on the other hand, there are intervening factors or elements that interrupt the chain, then proximity is not there. Finally, the courts look for actual quantifiable loss. If we're talking physical injury, they want medical reports. If we're talking loss or damage to property, they want realistic appraisals and assessments. Once a plaintiff has demonstrated to the court's satisfaction the merit of their case, it is open to the defendant to bring forward arguments as to why either they should not be found liable for the loss, or that in some way, shape, or form, the amount of damages that the courts will award, the amount of compensation, should be reduced. And on this slide, you see a number of grounds upon which the courts may temper their verdict. The first one, prescription, is based upon the concept that if you have continuously behaved in a certain manner over an extended period of time, then you have acquired a right to do so in future. Probably the most familiar aspect of this is a right of way. So that if you or others have habitually crossed a piece of land in many jurisdictions, such as Nova Scotia, the time period and the nature of the action have been codified in a statute. It will be 20 years of continuous use. Then the court will recognize that that use has merit and should continue to exist. The second, consent or acquiescence, otherwise known as the doctrine of laches, exists when either the plaintiff has specifically agreed to an activity or has not objected, being in full knowledge the activity was going to be carried out. Statutory authority relies on legislation that has been passed which authorizes an activity. It has to be specific in such a way that the harm or loss experienced by the plaintiff was an inevitable consequence of the defendant observing the stipulations of the statute or regulation. If a plaintiff acts in such a way that either puts themselves in harm or contributes to the harm or loss they experienced, these may moderate or temper the court's judgment in these matters. The court will take into account any effort by the defendant to cure or fix the problem or harm, and that is mitigation. If the action was of common benefit to both the plaintiff and the defendant, such as, for example, the removal of a tree between neighboring properties, where the tree was in imminent danger of being knocked down in a windstorm, then any loss or harm experienced by the plaintiff will be discounted in that case. The windstorm is an act of God, and Hurricane Juan is a prime example of that. Many trees were knocked down, there was extensive property damage, but no individual was held liable for any of that. If, in fact, the harm or loss occurred due to the actions of a third party that are neither the plaintiff or the defendant, then so long as the defendant had taken reasonable precautions to prevent intruders, then they cannot be held responsible. If the plaintiff voluntarily engages in activity like skydiving or downhill skiing, which are inherently dangerous, then they cannot complain of harm or loss. Normally, plaintiffs can't complain of loss or harm they experience while engaged in an illegal activity, nor can they complain if the action itself was judged to be an inevitable accident. If somebody steps out from behind a parked car into oncoming traffic, the driver of the car that hits them cannot be sued or charged for that. The Criminal Code contains several provisions which may be used in cases where an individual experiences harm or loss relating to environmental effects. If, upon investigation, it is felt that an offense has been committed under the Criminal Code, the perpetrator may be charged and the Crown will prosecute. The Crown needs to prove all of the elements of the offense as described in the Criminal Code beyond a reasonable doubt. A finding of guilt may result in a fine or incarceration or both. Criminal law seeks to protect society and individual citizens from harm. Courts, as we have seen, deal with disputes. They are, by design, adversarial in nature. The truth or validity of any claim made in court is tested by challenging the argument and the evidence that is brought to support it. Each side in a case is responsible for representing the interests of their client in the most vigorous manner possible, and it is for the adjudicator, the judge or judges, or judge and jury, to decide which argument is more persuasive. Courts apply the law. They may be a way to check government's use of power and to adjudicate rights and responsibilities or liabilities in cases. While courts exist because of Section 96 in the Constitution Act of 1867, tribunals have been created by governments as a mechanism for dealing with disputes in specialized matters. The table setting out the differences between courts and tribunals talks to specific differences between the two types of dispute resolution. Tribunals include boards, commissions, panels, professional bodies, and other decision-making bodies created by government through legislation. Tribunals are intended to be more accessible to the public or to the specific group that they have been established to oversee and regulate. They have no inherent power or authority, only that which is granted to them under the statute that created them. Tribunals are subject to supervision by courts to ensure they act within the law and the jurisdiction that is set out in the statute or regulation. Not all tribunals have final decision-making authority, although some may and some may make recommendations to government or other administrative officials. Litigation should be a last resort, particularly in situations where what we are dealing with are ongoing relationships, where it is preferable to find a solution rather than a resolution. In situations where we hope to find a solution, there are other forms of dispute resolution that may be favored. Among these are negotiation, facilitation, mediation, arbitration, or contract model. With negotiation, parties agree to meet and attempt to resolve their issues outside of a courtroom or a tribunal. Negotiation with the assistance of a third party or facilitator may be valuable because it assists the parties in moving the matter along. With mediation, the independent third party assists both in the negotiation and also helps to find common ground by representing interests of all concerned. An arbitrator involves a third party chosen, often under legislation or regulation, to help resolve disputes, and an arbitrator has the authority to make final binding decisions. And finally, contract model. A contract is an agreement or understanding between or among parties that sets out their understanding of an ongoing relationship. It will also typically include provisions to deal with situations where it is felt that one party or another is not adhering to the terms of the contract. We have spoken already about the court's role in reconciling the rights and responsibilities of individuals in private law or civil law actions, but what about when groups are involved? There are several procedural mechanisms described in the civil procedure rules to deal with these situations. The one that is most commonly understood is the concept of a class action, where a defined group of people will be represented in court for the court to decide whether a defendant has caused harm or loss to them. In order for a common law action to proceed in Canada, the court must first certify or recognize that this is an appropriate avenue or method to pursue. The plaintiffs must demonstrate that at least some or all issues are common to all of the members' claims, and that this approach is the best way of dealing with the claims in dispute. Courts have been cautious with respect to class actions involving environmental claims in Canada. As I said, the way to proceed is governed by the civil procedure rules of a jurisdiction, and it is most commonly used in relation to an event rather than an ongoing situation. An alternative to a class action is something known as a representative action, where the court sees that there are a number of persons who have experienced similar loss or harm, but chooses to recognize one and adjudicate in that case with the knowledge that the decision made will be applied in the other similar cases. The benefits of pursuing either class actions or representative actions include a more efficient use of judicial resources, improved access to justice, and a real opportunity to change the defendant's behavior or the behavior of others who are engaged in similar activities. How do you get to court? The first hurdle in getting to court is standing. Having the court recognize, as has been mentioned previously, that you have a legal interest and that you deserve to have your argument heard. The most common ways in which standing can be proven are by demonstrating an interest in property, harm to an individual, health, or financial loss, pecuniary. The courts will also recognize a broader public interest, and in such cases, they will ask whether or not a serious issue is being raised, the outcome of which will have broad public consequences. Does the applicant applying for standing in the court have a real or genuine interest in the litigation? And is the applicant in a better position to bring the action than anyone else? Often, applicants for public interest standing include non-governmental organizations. And for environment, an easy example in Nova Scotia is whether or not the Ecology Action Centre has applied to court to participate in the case. This is often referred to as an intervention. And apart from public interest groups, others who may apply to court to become involved include government departments, industry groups that represent a sector where an individual corporation is being challenged as to their activities, non-governmental organizations such as I mentioned previously, and others. As to the ways in which others may contribute or participate in the case, there are several options. The court recognizes value in groups or persons who have particular knowledge that will assist the court in understanding the situation and reaching a just conclusion. And the public interest is often recognized when a provision of the Charter of Rights and Freedoms is being interpreted and applied because of the broad ramifications of the decision. These 5 causes of action are all what are known as nominate torts. Tort is a broad field that encompasses all actions where individuals experienced harm or loss or damage. But not all tort actions relate to environmental cause and effect or issues. So these 5, negligence, strict liability or the rule in Rylance and Fletcher, nuisance, trespass, and breach of statutory duty, are all actions that may be useful in terms of adjudicating environmental disputes. Negligence law deals with the compensation of losses caused by unintentional but unreasonable conduct that harmfully affects legally protected interests. The plaintiff does not have to demonstrate that the defendant intended to cause loss or harm, but they must prove that the defendant knew or ought to have known that their actions could have a harmful effect on others. With strict liability, the rule originated from Rylance and Fletcher, where the defendant created a reservoir on a property. Water escaped and flooded his neighbor's property. And in this way, the damage was caused by an abnormal or non-natural use of the land, in the court's opinion, that resulted in actual damage or harm to the neighboring property, or it could be goods or person, whereas nuisance merely requires a usual but unreasonable use of land. This requires an unusual or unnatural use. The advantage with this is that once the act has been proven, then the plaintiff is entitled to a remedy. Nuisance is subdivided into two areas. Nuisance involves protecting possession and enjoyment of property. Nuisance is an annoyance. The plaintiff must show there was harm or loss of a use and enjoyment of property and that the consequence was a foreseeable result of the defendant's action. The plaintiff does not have to show that the defendant meant to cause the harm or loss. In private nuisance, once the plaintiff has shown an unwarranted interference with their property rights, they are entitled to a remedy. Nuisance often occurs when there are two conflicting legitimate activities. Examples of nuisance include noise, odor, dust, smoke, fumes. Elements that the courts will consider when deciding whether or not a nuisance situation exists include how long has the activity been going on, how serious is the consequence of the activity, what is the nature of the neighborhood, whether there is public value or merit in the defendant's activity, and whether the plaintiff is unduly susceptible to any effects of the defendant's action. In situations where a sufficiently large number of plaintiffs are adversely affected beyond that which can be described in a class action, then the nuisance becomes one of public nuisance. In these cases, the Minister of Justice or Attorney General is empowered to launch an action on behalf of the citizens at large. The issue or problem with this is that often these are activities that have been authorized or permitted under government legislation, and the minister may not be inclined to pursue an action. Trespass relates to activities that affect an individual, such as battery or assault, or property. In either case, where trespass is deemed to have occurred, a plaintiff's claim will be upheld once the act has been proved. There is no need to prove intent or loss or harm in relation to the trespass. However, if the plaintiff can prove trespass, he or she has a cause of action and is entitled to a remedy. Trespass can be based on a single incident. The plaintiff does not have to prove damage or fault. Where environmental issues are concerned, causes of action such as trespass can protect land against any undesired intrusion. The drawbacks to this action are only the person in possession of the property may launch an action, and the act must have been directed at the property in question as an intentional act. Defenses to trespass include consent, involuntary act, necessity, statutory authority, and prescription. Plaintiffs or individuals may appeal to a court for a remedy based upon a statutory clause, so long as the statute specifically allows for that. A statute cannot be used as the basis for a private law action without that specific authorization. Breach of a statute by a defendant may be an indication of negligence and may be referred to as a useful standard of reasonable conduct, but it is not in and of itself grounds for a finding of fault. The most common remedy that a court will award are what are known as damages or monetary compensation. There are several different categories of damages. The first is what are known as nominal damages. Nominal damages are awarded in situations where a plaintiff has proven to a court that a tortious act occurred and that the defendant was responsible. However, for various reasons, the court finds that an award of a substantial amount is inappropriate. So, for example, in situations where the defendant's acts have caused harm or loss to a plaintiff, but the amount of harm or loss is inconsequential, the court will award a token amount. So it may be $1. General damages are found where the court is actually compensating for the loss that the plaintiff experienced. So the court has made a determination that the defendant is liable, and then arguments will be made as to what is an appropriate amount for the plaintiff to receive as a consequence. If it is difficult or impossible for the court, or the arguments are not sufficiently specific for the court to make a finding as to the exact loss or harm experienced, then the court will award special damages, a best guess, where actual amounts cannot be quantified. Finally, it is open to the court to award exemplary damages where it feels the defendant's actions were particularly egregious, heartless, careless, which are meant to be punitive in nature. Beyond damages, the plaintiffs may apply for another suite of remedies known as injunctions. Injunctions are orders made by the court. The most common injunctions are mandatory or prohibitory injunctions. And as the descriptors suggest, with a mandatory injunction, the court is requiring that the defendant undertake a certain action or activity, and with prohibitory, that the defendant cease to engage in a certain action or activity. There are other forms of injunction which the courts may use, but those two are the most common. Injunctions may be awarded in applications to the court where one party anticipates that unless the court intervenes, they will experience some harm or loss, and the defendant is not available to answer to the plaintiff's argument. In those cases, the courts will issue a temporary injunction until such time as both parties can appear before the court and arguments be heard on both sides for a final determination. Another remedy that a plaintiff may apply for is something known as a declaration. A declaration is an official statement by the court as to the state of the existing law that governs any specific relationship. Costs are typically awarded to the successful party in any legal action. If the plaintiff is successful in persuading the court as to the merit of their case, then the court will allow them to recover the cost of bringing the action from the defendant. Or, if the plaintiff is unsuccessful, the defendant may apply to the court to have their costs covered by the plaintiff. Occasionally, in exceptional circumstances, the courts will say, let the costs fall where they lie, which means that each side carries the burden of their own costs. Costs, at any rate, are determined in accordance with an official scale and may or may not represent the actual cost of pursuing an action. Private or civil law actions are designed to protect the interests of individuals and to allow them to be compensated for harm or loss in appropriate circumstances. The harm or loss may be as a consequence of adverse environmental activities, but these actions do not inherently protect the environment themselves. The results may have a beneficial effect as far as the activities that are going on which are causing harm or degradation to the environment, but the environment lacks standing, and without that, the courts cannot consider what is in the best interest of the environment through this kind of action. Other issues involved with using private or civil actions to protect environmental issues are causation. It may be extremely difficult to demonstrate the cause and effect relationship between a defendant's activities and the harm or loss to the environment. Quantifying damages is difficult because the courts, while recognizing specific loss or harm to individuals or property in terms of economic value, have not been willing to date to accept ecological value or aesthetic value in relation to these interests.